SJC-12017, Commonwealth versus Veovis.
Mr. Kerm, good morning.
Good morning. May it please the Court, Dana Curhan for Caius Veovis. With me is Christy Nader. The first issue I'd like to focus on is the sufficiency of the evidence. When I read a trial transcript, I look for the other shoe to drop. I look for that one piece of evidence that establishes guilt beyond a reasonable doubt more than speculation or a hunch. And frankly, in most cases I read on about page 2 of the testimony, that's where I find it. In this case, the other shoe never dropped. There's simply no evidence establishing from which the jury could find beyond a reasonable doubt that this defendant participated in the killings. There is absolutely overwhelming evidence that Mr. Hall and Mr. Chalou committed the crime. Hall could not keep his mouth shut. He ran around confessing to everybody, ran around making admissions, and there was physical evidence found tying Hall and Chalou to the killing. There was a lot of consciousness of guilt. They spent the whole next week disposing of evidence. But as to this defendant, there simply was nothing there. He was observed hanging out with Hall and Chalou the night before, and we don't dispute that. And he was last seen probably around 10 o'clock the night before, a couple of hours before the killing, with Hall and Chalou and two young ladies. And his vehicle was identified at around 6:30 the next morning. Hall dropped his car off at the Sutton residence, and the defendant's vehicle was seen picking him up. He was not identified or seen at that time. And he was first seen around 9:30 when they returned to the Sutton residence in the Jeep. So that was the first time he was actually observed in connection with Hall and Chalou. And no witness identified him as being an actual participant. There's no physical evidence, there's no forensic evidence. His vehicle was searched, and his vehicle, from the condition of it, obviously had not been cleaned out, and nothing of any evidentiary significance was found in the vehicle.
You've obviously carefully read the Commonwealth's argument and how they're marshaling the facts based on what was found in his home and the connections and going in and getting the cigarettes as well. And none of that really necessarily connects anything about your client to this particular victim. But at one point in Home Depot, he says, don't worry, you'll get him.
I don't think it was Home Depot, but it was during the course of the week. I think it was that discussion took place a few days before. There was Hall was complaining about one of the victims, about how the upcoming testimony, and he said, "Don't worry, you'll get him." There was testimony that I think one witness said he was always complaining. He was complaining like a woman. I know that's a sexist thing to say, but he was complaining like a woman, and he's always whining and complaining about everything. And I think the defendant said, "Don't worry, you'll get him."
Well, the point is that when you hear the argument on the other side and go through all the circumstantial evidence in your argument, well, it's circumstantial evidence, but there's no connection. That thing that you're looking for in the transcript, you're going to hear it's the comment that connects to him, connects to the victim. Don't worry, you'll get him.
I don't think that, "Don't worry, you'll get him," I don't think that establishes that he was participating in the crime itself.
The night before,
And apart from obviously other injuries, the three victims were shot, correct?
Yes.
The night before, the three men pick up firearms, and your client provides brake cleaner, and then Hall breaks down and cleans the firearms, correct?
What happens is
And then they later find brake cleaner in his apartment.
Yes, yes. They're all going over, the two young ladies and the Chalou and the defendant are going over, and Hall, in a separate car, are going over to the defendant's apartment. Hall then stops at somebody named Steve Hinman's house on the way there. He picks up 4 guns. He then comes over to the house, to the apartment. The defendant at that time,
On the 27th, right? This is the critical time period.
the Saturday night, the night before.
Yep.
The defendant goes upstairs with one of the young ladies and spends an hour with her. While he's up there, Hall and Chalou are sitting on the couch cleaning the guns. At one point, Hall says, "Do you have any brake cleaner?" He says, "Yeah, it's in the kitchen, and there's some," and I think he asked for gloves. There's some gloves there too. So he's cleaning the guns. The defendant comes down with the young lady that he was with and asks her if there was a plan for the 3 of them to go out and commit the murders. He actually asks the young lady to stay. She declines and she leaves. At that point, nobody knows what happened. It is, of course, possible that the 3 of them got into one of the vehicles and went and got the 3 victims and participated. It is also possible that the 2, that Hall and Chalou went off and committed the murder, and the defendant stayed home and did not get involved or did not see anybody until the next morning. And when he showed up to pick them up and give them a ride when Hall dropped his car off. So I think it's really speculation. And one thing I'd like to point out, the bodies were buried by someone named David Casey, who had a backhoe. Hall, of course, confessed to the whole thing. The way we know that there were 3 people involved is that Hall said there was a 3rd person involved.
You say the other guy?
He said the other guy, and he said he really enjoyed torturing and cutting up the bodies. Now, on direct examination, my brother asked Mr. Casey, did he say something about a 3rd person? And what he said was Langdon. Langdon is, and my brother points out that there's a question mark afterwards, and then he redirects him to what he actually said. But I think the point is, Scott Langdon was actually the whole scenario where they tried to frame the victim. They took him to upstate New York and tried to frame him for sexual assault and kidnapping. Langdon actually participated in that. He was Hall's roommate for a time, and I think the point is the only person who arguably was identified in Hall's statement in the Commonwealth's case was Scott Langdon. He never identified the defendant. He never said the guy with the horns and the tattoos and the filed teeth. He never said the satanic guy, the guy with the mohawk, anything like that. He never identified the defendant. So I think there were extensive efforts to dispose of evidence the following week. Those efforts were undertaken exclusively by Hall and Chalou. They had their Hall's car crushed. They washed out another car. They dumped evidence off of a bridge into the river. They burned clothing. And this all took place over the course of a week.
And no evidence that your client was involved with those?
No, he was at work that week.
And what about the medical illustrations that were found in his room that would be related to dismemberment?
Well, I think that's actually the second issue I'm going to argue, but I think the point is that's not dismemberment. That's surgical amputation. There were a lot of, there were illustrations from a medical textbook that were, some of them were cut out and put up on a wall, and some of them were in a briefcase.
That's too fine a point, isn't it? I mean, dismemberment, surgical, I mean, how do you find a diagram of dismemberment? You find a diagram of surgical procedures.
When you look at the testimony of the Commonwealth's forensic anthropologist, Dr. Pokaines, he was asked, is this, are these illustrations consistent with the injuries that you saw on the victims? And what happened was the victims, there were hacking motions, that some heavy, sharp object was used to actually cut through the bone. And he said, well, you know, it's not really consistent. These are surgical procedures that are illustrated. There are actually a lot of them, a lot of different ones. But this was using a fine instrument to cut through the joint and then sew it back up and create a stump. It's not my idea of decor. I don't think it'd be in Better Homes and Gardens, but that's something that the defendant seemed to like. But I don't think that's necessary. That's not dismemberment. That's not what happened to the victims here. That's a very precise surgical procedure that is illustrated in a textbook.
And we're assuming that none of the perpetrators were surgeons, right?
I'm sure you can assume that.
You and Mr. Capeless appear to differ as to the meaning of the evidence that occurred between 1:30 and 5:30 that morning.
Yes.
Why is he not right that we can make an inference that your client was with Hall and Chamu during that time period?
Well, I think my brother says that he was identified or seen at 1:30. He wasn't. Witnesses were asked, did you see who was in the vehicle? No.
And whose vehicle was it?
Well, that's the question. He was identified as a Jeep. He said, you know, what color? My client has a black Jeep. He said he thought it was yellow. He couldn't recall the specific color, but he thought it was yellow. I don't think we can establish that's the Jeep. This is, in that part of the state, correct me if I'm wrong, but I think a lot of people drive Jeeps or four-wheel drive SUVs, and we have a lot of testimony. The two young ladies who the defendant spent the night with the night before had a silver Jeep Cherokee. I think they're the witness who testified to seeing the Jeep at 1:30 in the morning, he said his daughter's boyfriend has a yellow Jeep. I mean, I think it's a fairly common vehicle out there, and I don't think we can establish, number one, that that was the defendant's Jeep, and number two, if it was the defendant's Jeep, that the defendant was in there. And even if we could, by 1:30 in the morning, I think the killing was over. So if he drove them there, or if he went and picked them up afterwards, or picked them up at some point after the killing, that probably doesn't make him a nice person, but it also doesn't establish that he participated in the killing. So I think that's a real problem for the Commonwealth. I'd like to focus also on the evidence that was found in the defendant's apartment. I think one of the young ladies described it as, to paraphrase, creepy stuff. And I think a lot of that evidence was really there to prejudice the defendant without any real probative value. That included a lot of weapons. So there was a machete, there was a cleaver, there were knives, there were a couple of baseball bats with spikes going through them. The Commonwealth conceded in its opening statement that they never found the weapons that were used in the killing or the dismemberment. They essentially made the same concession in the closing statement. In between, the Commonwealth kind of fudged a little and said, well, you know, it could have been, this stuff could have been cleaned, and maybe something there had been used. Well, the police and the Commonwealth's experts tested every one of those items at the defendant's apartment. Everything tested negative for blood, and they never seized it. They took pictures of it, but they never seized it. So the rule that if something in the apartment might have been used, it is admissible, doesn't apply because these things were not used. These things were not used in the killing.
I may have missed it, Mr. Curran. Did the baseball bats and the like photographs were introduced, but the items themselves were not introduced?
None of those items were introduced. There's no blood on them. They weren't seized. Because obviously the police didn't think they had any evidentiary significance. Now, if there was something unique about them, if, for example, the anthropologist came in and said, well, these injuries had to have been caused by a machete, and the defendant had a machete, maybe they're admissible.
But the prejudice comes in the introduction of the photographs.
The introduction of the photographs.
Objection?
Oh, yes. There were 3 motions to keep out all of the items in the apartment. There were objections, and so this was very well preserved.
And the judge's ruling was based on what?
It didn't really, there wasn't really a lot of discussion.
Isn't this the evidentiary vehicle? It's the content of his consciousness. And that brick alone is almost nothing. But it's the content of his consciousness. Look at this dismembered stuff in the house, the art or whatever you want to call it. Look at the type of weapons he's interested in. And look at what happened to these people. That's it. It's not hard to figure out what the evidentiary vehicle is. It's not that they were used in the crime. You can argue about whether or not that brick gets you to what Professor McCormick called a wall, but it's not complicated as to what its evidentiary vehicle is.
Well, my contention is that none of these things had anything to do with the murder. They showed that the defendant is a scary guy. And, you know, some of the things that were introduced were sculptures with skulls and knives in them. And, you know, and he's got an interest in, you know, some pretty dark stuff.
Well, it's the content of his consciousness. And if he has these type of things, does that make it more likely than without these type of things that he was participating? That wouldn't even get you over a required finding. It's just a brick along with everything else. But it's not complicated to understand its evidentiary vehicle for admissibility.
I mean, the jury certainly would have looked at it that way. The jury certainly would have said, you know, this guy, first of all, take a look at his appearance. I mean, and I have a couple of pictures of him in the record appendix. Take a look at his appearance. Take a look at all of this stuff. I think it's around 55 or 56. Take a look at all of this stuff that came in, all of these sculptures with skulls and crossbones and all of these, you know, huge weapons and a baseball bat with spikes on it. And now look at all these illustrations up on the wall showing human dissections, medical textbooks, but, you know, showing human dissections. What that shows is that, you know, he's a pretty bad guy and a pretty scary guy.
That's the unfair prejudice of it. That has nothing to do with its probative value. They're 2 different things that get weighed together. Fair enough. But the evidentiary vehicle, as far as its probativeness, is not complicated, and it can't be looked as an island. It can't be looked at as one brick. What you're talking about is why it shouldn't come in because it's unduly prejudicial. Fair point.
It shouldn't come in, and it has no probative value. It has absolutely no probative value.
Well, you say that,
I understand that.
but we have Hall is saying this third guy was somebody who enjoys torturing and cutting up bodies. And is it not reasonable to say, well, I look at this particular fellow, and that appears to be consistent based on his room with somebody who enjoys cutting up bodies and...
Well, I don't think you can. I don't think you can draw that interest. That he may think this stuff is cool, and he may have this stuff, and he may collect it, but I don't think, I don't think that really makes the connection.
You're just completely confusing admissibility of evidence with sufficiency of the evidence. He's interested in this stuff, that's the content of his consciousness, that's the theory as to what was going on with these type of killings.
Well, I think probably the cutting up of the bodies is separate from the killing. You know, is he a person who actually, you know, committed the murder, and that's what we're,
Precisely.
and I don't think we get there with any of this evidence.
Mr. Curran, can you just tell me, is this the defendant?
That's the defendant.
Did he look like that at trial?
Yes, he did. I think he grew his hair out.
Did he have those things out of his nose and?
I think the things out of his nose were taken out, but the horns implanted in his head were still
There
there.
are horns in his head that we can't see? Oh, and what about the horns over here?
I don't think,
Thighs, those things can come out?
the things in his nose, I think, were out. There are some horns in, 3 on each side in his forehead that I think you can see.
Yes, right above here.
Right. And above his eyebrows going out. There are 3 on each side.
All right, thank you.
I mean, you're referring to the tattoos that are here?
No, there are actual horns implanted, surgically implanted in his head. And his teeth are filed to points. So the jury was out for 6 days, and I think had he looked like a normal person, I think probably it would have been a not guilty. But,
And that's a tattoo on his face?
yes.
So what do we do about that?
Well, we can't do anything about his appearance, but I think ultimately the Commonwealth failed to establish his guilt beyond a reasonable doubt, and even if it did, the admission of all of this stuff from the apartment severely prejudices him and entitles him to a new trial.
Okay, thank you, Mr.
Thank you.
Mr. Caples, good morning.
Morning. May it please the court. I'm Berkshire District Attorney David Caples. I appear on behalf of the Commonwealth, and I was lead trial counsel in this case. At the outset, the defendant concedes that the 2 co-defendants, Hall and Shalhoub, were involved, but claims that the involvement of the defendant is based on pure speculation of the evidence. Now, it's the Commonwealth's position that there was not only sufficient circumstantial evidence of his participation, but also that it was buttressed by evidence of motive, knowledge and intent, consciousness of guilt, and most importantly, his admission that he was a partner with the other 2. All of this together created a web of interconnected evidence that proved the defendant participated with the other 2.
When you say partner, you're referring to the statement made at the jail?
Yeah, that's correct. That he says to Shalhoub. The 2 of them have just been arrested. The police have taken them individually, Shalhoub first, then the defendant Veovis. They have said to each one of them they are now being charged with murder, that they have found the bodies, and they also proceed to tell them that Adam Hall on a previous occasion had offered to the police to rat out his associates in the Hells Angels. They asked them if they wanted to talk. Each one in turn declined. When the defendant came back down, he turned to Shalhoub they were in adjoining cells and says, "Did you hear what they say about our partner? He's a snitch," or he's a rat. Now, there's a lot of things he could have said. He could have said our friend. He could have said our buddy. He could have used an expletive. But he chose the word partner. And in the context, I would suggest to the court that the only meaning that has goes back to their involvement in the kidnapping and murders of the 3 victims.
Now, I get the motive. The motive you claim, I understand, to be that he wished to be a member of the Hells Angels and was trying to get a motorcycle. That's your motive?
Well, his motive was to become a member of the Hells Angels. It was demonstrated both by Hall saying to somebody that the defendant was a prospect. The defendant himself told his boss that he needed a loan so he could buy a motorcycle because a motorcycle was necessary to get into it. Every time that he's seen by the police and when he's arrested, he's wearing so-called support garb of the Hells Angels.
What is support garb? I couldn't figure that out.
It is garb that is similar to Hell's Angels, like the vest, and you see there is the photograph. The second photograph shows him, and he's kneeling down at the gas station, and it shows support for the Berkshire County chapter. It is Hell's Angels are very strict about anyone wearing anything that actually says Hell's Angels on it, so he's only allowed to wear things that show this kind of support. He also had in the apartment T-shirts that were support T-shirts, stickers both in the Jeep and in the apartment saying support the local Hell's Angels chapter. So all this together demonstrating that he was somebody who was interested in doing it. Hall was the sergeant-at-arms of the local chapter and obviously could be influential in doing this. Now, Hall obviously himself had a motive, a very clear motive, for committing these.
Was there any testimony about Hell's Angel practice that you need to make your bones or some other means in order to gain entry?
The Commonwealth never suggested that. What the Commonwealth is suggesting is Hall has this motive about getting rid of Glasser, the witness for his upcoming trial, and that he recruits Shalhoub and the defendant to aid him in this. In considering the circumstantial evidence of the defendant's involvement in the kidnapping and murders, it's very critical to look at the entire context of this. You have first that Hall's trial is upcoming. It's looming. It's going to be, he's scheduled to go to trial in several weeks. He's already had previous attempts against Glasser to try to silence him, and he's vowed that, in fact, he's not going to let him get away this time. Before his last attempt, this New York caper, he had said to one of the people involved, if this doesn't work, he's going to have to disappear. Now, there's also testimony that only just prior to this weekend of the murders that Shalhoub and the defendant start hanging around with the defendant. It isn't that they happen to see people who normally hang around with each other. All of a sudden, these two appear, and they're with him. Over the course of this weekend, they are virtually inseparable. Now, as described, when talking to Casey about what had happened, Hall says that there was two other people, Davy and this other guy who enjoyed torturing and cutting up the victims. And that also it's very important to understand that on the night that the kidnapping and murders occur, Tropical Storm Irene is raging through western New England. And so this weekend, the Commonwealth asserts that the killings occurred what would actually be early Sunday morning, not according to what the defendant said, more likely between 1:30 and 5:30, the critical time when people are seen. And the Commonwealth asserts that based upon all the evidence together, the defendant's involvement is shown by the fact that circumstantially, these three were absolutely inseparable from late Friday afternoon, early Friday evening, until early Sunday evening when they drop off the Buick with the bodies in it. Friday afternoon and evening, they're driving around together in the gold Buick with a young woman, and they end up at the Hells Angels clubhouse. It's at that point where Hall is ranting about Glasser and the trouble that he's caused him, and when the defendant says, "Don't worry, you'll get him," it's also significant that Shalhoub joins in that, in saying, "Yeah, that's right, you'll get him." The following morning, the defendant and Hall are outside the defendant's girlfriend's apartment in Pittsfield. That afternoon, all three of them go together and leave together in the gold Buick at the Hells Angels party that's in Springfield. On that evening, they're all back at the Hells Angels clubhouse. There's the gold Buick there. The two women are invited down. They pick them up, and the defendant, Shalhoub, and the two women go in the women's car, and Hall goes alone. Significant that on the ride over there, they notice Hall turning off in Lenox, which is en route from Lee to Pittsfield, which is at Steve Hinman's house. Significantly, the girls testified that neither Shalhoub nor the defendant wondered, where's Hall going? Why is he turning off? This is where he got the guns that the Commonwealth alleges were used in the murders. All of them meet up eventually at the defendant's apartment. Hall pulls out a dog food bag, which has the guns in it. He asked the defendant for brake fluid and gloves in order that they can clean the guns. The defendant doesn't just tell them where they're at, he provides them to them. There was some discrepancy as to where the defendant was during the time the guns were out, but it was for the jury to decide, based upon the credibility of the witnesses, whether or not he was, and there was testimony indicating that he was present when the guns were out at the apartment.
So what gets you over the mere association? Every one of these inferences is another inference of mere association.
Right.
So where do you get beyond taking all these inferences together to beyond mere association?
Well,
if the evidence allows.
Going forward, it's the Commonwealth's contention that from there, that during the time when that obviously the kidnapping and the murders occur, that these three are together, they are absolutely inseparable. Going from there, at 1:30, Hall is seen at Madison Avenue, and he's a passenger in a Jeep. He gets in the passenger side and leaves. 5:30 a.m. is when Hall is getting 3 candy bars, and then he's getting the cigarettes and the cigars the defendant smokes. The Hall does not smoke. Shalhoub smokes that brand of cigarettes. Immediately after that, the defendant and Hall in the defendant's Jeep are identified as being back at Madison Avenue, and they're dropping off the Buick. At 9 a.m., all 3 of them are returning and identified as being in the defendant's Jeep, and then they turn the Buick over to the girls and ask them to come for breakfast. All 3 of them are together at the defendant's home in Peru. During that early afternoons when Hall goes across the border into Canaan, New York, an adjoining town right on the border, to tell him about what had happened.
I keep on having Commonwealth versus Zanetti in my mind with every additional sentence. So if you've proved beyond a reasonable doubt with each one of these, unbelievably compelling evidence that the defendant was there when it happened, where do you get past that point? Because that's not going to be enough that he's there.
Well, I think, you know, you add to it Hall's statement about that third person, which if you, having established that it was in fact the defendant, this person enjoyed torturing and cutting up the victims. That shows clear participation in this. And the fact that he's not only associating before, during, but also afterwards, because the evidence indicating that on Sunday evening, when they've got the bodies in the trunk of the dismembered remains of the victims in the trunk of the Buick, that is dropped off at Pavoni's, that they leave in a Jeep, which I think together with all the evidence, it's a fair inference that is the defendant driving his Jeep.
Can you remind me what time the Commonwealth asserted that the killings happened? I've lost that detail somewhere.
The Commonwealth asserts it happened sometime between 1:30, when Hall shows up at Madison Avenue, and around 5:30 in the morning when he shows up at the A-Mart in Pittsfield, and then they drop shortly thereafter, drop the Buick off at Madison Avenue. It could have happened before. The Commonwealth has never located we've never been able to identify the crime scene, and as stated, never identified any of the weapons used in this. But there was considerable evidence and testimony produced that, in fact, measures were taken to make sure that this did not happen. The defendant has argued there was no forensic evidence, DNA, fingerprints, or anything of life tying this defendant or either Hall or Shalhoub to the victims in these crimes. But also, what's significant is no forensic evidence tied any other person to the victims in the crimes. Obviously, we're not going to conclude that nobody did this. It's simply that that evidence was not there, leading to the inference that, in fact, measures were taken to ensure that there wouldn't be such kind of evidence. By the use of gloves, the fact that this was committed during a rainstorm, which numerous witnesses talked about, and Hall himself said he enjoyed doing it in the rain.
Mr. Capers, let me ask you something pursuant to our authority under Rule 33, or Section 33E. This case is replete with co-conspirator statements. As Mr. Curran said, Hall couldn't keep his mouth shut, and it comes into the co-defendant trial. And I know the defendant need not be present during these statements. I get the statements that were made to Clark. I don't think you get much more in furtherance of a conspiracy when you're burying the dismembered bodies. But there were statements made to people like Rose Dawson and others about the victims and disparaging descriptions of them, how they had gone missing. How are those statements made, and primarily to female witnesses, how are those statements in furtherance of a conspiracy?
It was the Commonwealth's contention, which the judge accepted and made the ruling on it, that both prior to and afterwards, in not only speaking with Casey, who he was trying to get Casey involved in the crime.
I think
And
Casey,
I'm going to
put
get to
Casey-
that.
Right.
That it was a combination of getting people involved, but also when he talked to Rose Dawson and others, by telling her what had happened, he made, the suggestion is, to her mind, made her complicit in this, and now she's involved. In fact, if you carefully read the evidence when she comes to testify, she's an extremely reluctant witness who has to have the evidence dragged out of her about what had happened and what, in fact, Hall told her.
Because if we don't go there, then we have a Bruton issue, right? If it's not in furtherance of conspiracy, then there's a Bruton prohibition.
Right. That has not been raised by the
I know,
defendant on appeal,
That's why I said it's 33 issue.
but I don't think that it would be appropriate for that. I think these are collateral statements, particularly in this case where the defendant concedes that Hall was involved. A statement to Rose Dawson indicating about the victims and where they were in the apartment when they were kidnapped would be irrelevant to whether or not the defendant's involved. He's not even mentioning that. It's only about the victims themselves. All right?
And going back to the timing of the killing, are there hard facts indicating that any of these three were alive at some point in time? I mean, there was, I guess, but what's the latest time in which we know that one of these three victims were alive?
At sometime between 11 and 11:30, and I'm trying to remember, it's like 11:18 or
on Saturday night?
11:27 on what would be Saturday night.
So Saturday night, there's
There's a phone call between Robert Chadwell, who is the neighbor who lived across the street, who happened to come over and be visiting there, with his boyfriend, who was over in New York, and it was the last time that he spoke to him. And that's the last contact that they have. People have described them being, not only on Friday, but during the course of the day on Saturday, seeing them, they were outside, and then there's that phone call. They are not heard from at all on Sunday morning. In fact, the upstairs neighbors go to try to get out. Glasser's truck is blocking it. They knock on the door, there's no answer. The television is still on. The television is on, no one's responding. Monday, Tuesday, finally on Wednesday, the police go to the apartment.
So Sunday morning when they go by to visit, to knock on the door, what time is that? Is that early in the morning or?
The upstairs neighbor says there's a knock on the door that, she was very unclear about the time. She thought that it was maybe around midnight.
In terms of the knock on the door to say, move your car, or that was in the
No,
morning? I
no,
thought?
the knock on the door, the upstairs neighbors have left.
Oh, I see. They heard some knock on the
They
door.
heard a knock.
After 11:18.
With nothing else.
So the
They
inference.
didn't
the
hear
inference-
anybody answer the door, they didn't hear anybody come in, anything else. They said they had heard voices and people talking during the course of the evening, but they hear this knocking, silence after that, and it's the following morning that they go to try to get out and can't because Glasser's truck is blocking.
At what time is that? In the morning, just ballpark, just kidding.
It's, clearly it's after 5:30 in the morning. It's later in the morning,
So your
9, 10 o'clock in the
I'm
morning.
sorry, So your inference, I mean, you have certainly those two inferences, but your inference that it occurred between 1:30 and 5:30 is based more on the conduct of the defendants
That's correct. Although,
within the window that you've described.
right, although the Commonwealth is saying it happened, I'm saying it's likely happened then, but it could have happened even before 1:30. The last time the women are at the apartment and they leave at about 11 o'clock, and sometime between there and 5:30, when they're then seen at the A-Mart and then at Madison Avenue, that occurred sometime over that period in early Sunday morning during the raging tropical storm. Unless there are any further questions
I
from the
just
court.
have one left at least, which is, what about all the unusual weapons, the interest in the devil, the surgically removed dismemberment art? What do you say about the undue prejudice of that?
Well, first off, that it was admissible to show the defendant's intent and also his knowledge, and the fact that these were available weapons to the defendant. Defense counsel was trying to claim that there was evidence saying these weren't the crime victims, and the Commonwealth, in fact, did argue that they could have been used in the perpetration of the crimes. The fact that they tested negative for blood did not rule them out, considering other evidence indicating that measures had been taken to make sure that no particularly forensic evidence would be available afterwards.
Was there any expert testimony by anybody from a crime lab or such that say it's entirely possible to completely wipe clean one of these macabre weapons?
There was testimony, yes, from one of them. They not only talked about why they use gloves so that they will not put fingerprints or DNA on items that they handle, but also that items that have evidence such as blood could easily be cleaned, even if only just by water, and that in fact a rainstorm, in fact, could destroy that kind of evidence.
That would, I'm sorry, and that would not be detected through any of the sophisticated means of presumptive testing that's used?
They talked that they were just doing this presumptive testing and on that. There was no.
Excuse me, was there evidence or some sort of testimony linking the possibility that these types of weapons were used to commit the crimes?
In addition to the gunshot wounds that each of the three victims had received, there was a total of 21 different knife-type wounds, whether by stabbings or slashing. Some of them were quite severe. Both Robert Chadwell and Edward Frampton had been gutted from the crotch all the way up to the sternum. We allege that this was a torture, that it was done in the full view of Glasser before he was murdered. Additionally, Frampton had a very long and very deep gash in the back of his, on his upper back on the shoulder area that was so deep that the pathologist who testified, Dr. Hammers, indicated that this would have, that in fact it had severed his spinal cord and he would have been paralyzed from that.
But is there anything that connecting that with the kinds of weapons that were taken? I mean, the crimes would have been done with you would have needed a big knife to do this, or a knife.
There was no testimony specifically about those particular knives, particularly, as they said, they weren't collected. We only had photographs of them. But there were various types of wounds, some of them very deep, some of them not so deep, and some of them slashing laceration type of wounds. As far as the machete and the hatchet, Dr. McInnes did specifically testify that they were consistent with the types of tools that could have been used for the hacking, as he described it, that engaged in the dismemberment. As far as the illustrations were concerned, these were from a collection, a boxed collection of 19th century anatomy illustrations. Several of them, certain of them had been taken out, carefully cut out, and carefully put together in a collage. It's important for the court to understand this was not only put together carefully by the defendant on a large-scale collage, but that it was on the apartment he lived in on that weekend when the kidnapping and murders occurred. He moved several days later into the apartment upstairs, and he took it down and carefully replaced it in the new apartment. The photographs that's shown there is actually in the new apartment, but the women testified they had seen it there previously.
But no indication of where these murders took place. Do we know where the murders in fact took place? It wasn't like it was in the room where the illustrations were.
No, certainly not. And the indications were that it was outdoors somewhere, and that only coming from Hall's description that it happened during the rainstorm, and he enjoyed doing it in the rain. But the Commonwealth never identified where the murders took place,
Or the dismemberments, more particularly.
or the dismemberments, suggesting being likely at the same place, but not, there was no indication absolutely where it happened. We were not able to find that, only that it in fact occurred because of the condition of the victim's remains.
All right, thank you.
Thank you.
We'll take our morning break.
All right.